In a bid to restore balance in the Commission, Attorney General George Brandis appointed Tim Wilson as the head of Human Rights Commission, maintaining the focus to promote freedom of speech. Only 3 weeks officially into the job, Australia's new and controversial Commissioner has community groups and political leaders concerned over proposed changes to amend the Racial Discrimination Act. By doing so, his first priority is to push for the repeal of Section 18C of the legislation. This deals with whether a matter offends, insults, humiliates, or intimidates someone on the basis of race, colour, or ethnic origin.
The reality is when we're talking about speech, and particularly when we're talking about issues around race, national identity, and ethnic origin, we're also talking about culture. The simple reality is we're talking about cross-cultural speech. It's very hard to know what may in the end insult, offend or humiliate an individual or even intimidate them, and therefore it goes unnecessarily too far in shutting down free speech, and we are not a better society for that.
The Act won notoriety when columnist Andrew Bolt was found in breach for a column regarding fair-skinned Indigenous Australians. With the belief that free speech should only be shut down to the extent that it leads to conflict with other human rights or situations of violence, Mr. Wilson makes it clear that only then should free speech be limited.
There is a limit to free speech when it results in action, in particular with relation to violence. But I think, there are grey areas which on balance I think I defer towards protecting people. So when we're talking explicitly around intimidation, I haven't, called particularly for the repeal of the intimidation component. I'm open to seeing how that can be accommodated, but intimidation is already included under a large number of state and federal laws, and so by continuing to include it in the Racial Discrimination Act, it adds nothing more than what exists elsewhere.
Attorney General George Brandis has told a Senate estimates hearing the government is considering the move, but is yet to decide how extensive the legislative change would be. Members of the Human Rights Commission are, however, divided over the plans to water down legislation. Race Discrimination Commissioner Dr. Sud Palmasan says that by dismantling what he describes as a vital part of the Act, the move may warrant racial hatred.
Society takes its cue from political leadership, and our laws play an important role in setting the tone for how we conduct our life together. We know from research that has been conducted by psychologists, for example, that when people commit an act of racism in public, for example, abusing someone on a bus or on a train, they in fact believe that the majority of those around them approve or endorse their actions. And that's one reason why, with the Racism It Stops With Me campaign that the Human Rights Commission runs, we encourage people to stand up to racism wherever it happens, to speak out against it. Now, if we're doing that kind of work, it's only consistent that our laws don't remain silent on racial vilification. Silence, in this case, could amount to sending a signal of approval.
So basically, you are standing against Mr. Wilson's proposal to repeal Section 18C.
I believe Australia needs to have strong and effective laws which protect people from racial discrimination, including racial vilification. Our laws are a reflection of our values, and if we are a multicultural society, if we are a liberal democratic society, then it is only proper that we have laws which value civility and racial tolerance.
According to the 2012-2013 report by the Human Rights Commission, complaints of racial hatred had increased by 60%. Mr. Wilson is convinced that Section 18C has in fact contributed to the increase, essentially due to the lack of views and ideas being publicly proposed, exposed and corrected.
But as you point out, there has been an increase in the amount of racial hatred and verbal racial abuse that's been occurring in the community at the same time that we've had this provision in the Racial Discrimination Act. This is part of the problem, is people see it as a solution when in fact what it's actually doing is encouraging people to keep their racist views to themselves, not having them aired, challenged, responded to and corrected, because when people hold their opinions to themselves and don't air it, they don't go away, they fester and they actually become more targeted and more malicious in the process. So maybe the Race Discrimination Act and Section 18C in particular is having the reverse effect of what people actually think it to be, but that's a debatable point.
Member of the New South Wales Legislative Council, Shuket Musulmani, finds it strange for a member of the Human Rights Commission to want to repeal the section, which he says could ultimately result in adverse troubles for the community.
this would be outrageous. Our community should stand up against this. We should write to Tony Abbott. We should write to George Brandes and write to Tim Wilson, the head of the Human Rights Commission, and really attack this, because the whole process of removing Section 18C of the Racial Discrimination Act, by removing that particular section, means that the Racial Discrimination Act has no teeth, and therefore people cannot take those who slur, abuse, or offend others to court. Otherwise, if you wanted to take them to court, then you'd have to use other means, and that would include defamation laws. And defamation libel or defamation laws, as you know, is a very expensive court process, and no one in any community, unless they're multimillionaires or very, very rich, to be able to take on cases for defamation. This is unacceptable, and the community should not accept it.
Mr. Wilson has argued that the best way to counter racist insult and the like is non-legislative pushback, or, in other words, fighting speech with speech. Dr. Soutphommasane argues that there is certain naive optimism in people having to rely on letting good speech override bad speech.
The thing to bear in mind here is that we shouldn't throw the baby out with the bathwater. It's not enough, in my view, just to have social sanctions in place. The law also has a role. And it's one thing to say that you can fight bad speech with good speech. If, for example, you are someone who is well-educated or professional or from an affluent background or speaks from a position of social privilege or power. But we know from our consultations and our research at the Human Rights Commission that one of the effects of being exposed or subject to racial abuse is that it can belittle you and intimidate you, and it can get in the way of you exercising your power to express yourself. This comes from the testimony of those who have experienced racism. They say that racial abuse makes them less likely to speak out. So I think if you're someone who is confident or comes from a particular social position, it may well be the case that you have the means to fight back with speech. But if you're a member of, say, a vulnerable community, or if you don't necessarily have a strong command of the English language, or don't have a sophisticated ability to make an argument in public or to stand up for yourself in public, then I don't think the argument applies with the same force.